This is Paul Turner, the Immigration Barrister to Imperium Chambers. Thank you for subscribing or watching my channel. If you have an immigration problem, please get in touch with me and I'll do my level best to help you. And hit the notification button for up-to-date immigration news as it happens. Today I'm going to be talking about Article 3 and recent developments in case law. Recently, the Upper Tribunal have reconsidered having it been remitted the case of AM Zimbabwe in the case of AM Article 3 health cases Zimbabwe 2022 UKUT 131 IAC, for those that are interested in looking it up. This seems to be an attempt by the Upper Tribunal to water down the effect of the Supreme Court decision in AM Zimbabwe versus the Secretary of State for the Home Department 2020 UKSC 17. The saving grace is that each case will need to be determined on its own facts, its own merits. So it's vital that anyone that is seeking to argue a case under Article 3 has the case properly prepared. I can help in this regard, or if you don't want to use me, which is perfectly understandable, then please use an experienced immigration practitioner to prepare the case, as if anything is missed, any application or subsequent appeal could well be dismissed in the light of the new case. Turning back then to the Supreme Court's decision in AM Zimbabwe, that adopted the new interpretation of Article 3 cases as identified by the European Court of Human Rights in the case of Paposhvili versus Belgium, application number 41738 of 2010. AM Zimbabwe and the Supreme Court and Paposhvili materially lowered the threshold for challenging a person's removal from a country on the basis of their serious ill health under Article 3 of the European Convention of Human Rights. The old threshold for Article 3 used to be found in the case of N versus the Secretary of State for the Home Department 2005, UKHL 31, which is also to be found reported 2005 2AC 296, for those that wish to look it up. In that case, Baroness Howe stated, and she was quite clear, in my view, therefore, the test in this sort of case is whether the applicant's illness has reached such a critical stage, i.e. that he is dying, that it would be inhuman to deprive him of the care which he is currently receiving and send him home to an early death unless there is care available there to enable him to meet that fate with dignity. This was a major retrenchment from the previous case of N and the case before that of D. In contrast, the new test, if it can be described as a new test, set out by the Upper Tribunal in AM Zimbabwe, is that the removal must result in a serious, rapid and irreversible decline in the person's state of health, resulting in an intense suffering or significant reduction in life expectancy. It is no longer necessary for a person to die immediately upon or shortly after return to their home country, something which was previously the case, especially in N and in particular in the even more harsh case of D. The significant change in the Supreme Court's case has resulted in many successful appeals, especially in some cases I've done here at Imperium Chambers. The reason that I'm now turning back to considering Article 3 cases, although AM's case was successful in the Supreme Court in law, his case was remitted back to the Upper Tribunal to consider the individual circumstances of his case in the light of the newly established law that I've just identified and was stated by Baroness Howe. That decision has been promulgated in a case which I've just referred to, which is AM Zimbabwe 2022 UKUT 131, not the Supreme Court case. Although the case does not change the state of the law, it is a useful judgment in showing the approach that the courts will take in Article 3 cases. In that the particular facts of the case are that AM himself is a Zimbabwean national who obtained indefinite leave to remain in 2004. He was then given a 9-year prison sentence, following which he was given a deportation order, not surprising. AM is unfortunately HIV positive and is currently managing his condition through antiretroviral treatments, monitoring and testing, as are a lot of other people. Now, the Upper Tribunal summarised the legal principles before deciding the case and followed and set out the following. Firstly, that the person must show that they have discharged the burden of showing that they are a seriously ill person. A minimum level of severity must be shown that the person meets the threshold of Article 3. It's a higher threshold, obviously, than Article 8. They must then adduce, and this is the crucial factor, they must then adduce evidence capable of demonstrating that substantial grounds have been shown for believing that they would face a real risk that they will face on account of the absence of appropriate treatment in their country of origin, or the lack of access to such treatment, a serious and rapid irreversible decline in their state of health resulting in intense suffering or a significant reduction in life expectancy. The next part of it is where the person has raised a prima facie case, so they put forward evidence to show that this is likely to happen. The country seeking to counter the removal can do so by obtaining evidence to dispel the serious doubts about Article 3. I.e. the country, say Zimbabwe for example, could show, well, actually we do have the treatment and the person's not going to suffer. However, if these serious doubts persist after looking at the returning country's evidence, which will often be non-existent, it may be necessary to obtain individual assurances from the receiving state, Zimbabwe in this case, that appropriate treatment will be available. Again, that's unlikely to happen. So the burden is then going to be on to the appellant, and it is obviously usually, or nearly always on the appellant's case to prove their case, save for deception cases. In AM's case, reports were obtained from 2 experts who disagreed as to the availability and affordability of HIV treatment medication in Zimbabwe. Oddly, in this case, the Home Office did actually instruct an expert. The Upper Tribunal was heavily critical of both experts' opinions, neither of which provided sources for their conclusions. The Upper Tribunal were also concerned about AM's credibility. Although this in itself did not change the state of itself, change the state of the decision, it did have an impact on the tribunal's assessment that he had provided. So again, this goes back to the issue of preparation. AM's case was ultimately dismissed, the Upper Tribunal holding that there was medication available for him in Zimbabwe costing around $2 a month. So again, whilst this case did not change the state of the law, it was interesting to see where the Upper Tribunal's take on AM Zimbabwe and the Supreme Court's decision. And it also sets the benchmark as to how the Upper Tribunal will be considering such cases in the future. So there are essentially a number of tests. Firstly, one has to meet the minimum level of severity and threshold and risk. Secondly, it will be up to the receiving state to rebut that evidence and say, well, actually there is treatment available. And lastly, and this is the fact-sensitive point, it will be necessary for the appellant, probably in the absence of anything from the receiving country, to show that their health will deteriorate to the extent that Article 3 is engaged. And this is where the case becomes fact-sensitive, because it will be necessary to provide proper evidence. As can be seen from the Upper Tribunal's decision, the Upper Tribunal were not impressed with either expert, either the expert put forward by the appellant or indeed the Home Office's own expert as to the level of or availability of treatment. It is also noteworthy that in assessing whether or not the AM would receive such treatment or could obtain such treatment, that the court also looked at his general credibility in finding that actually there was available treatment which would prolong his life and therefore take away the risk of a serious risk of irreversible harm and either him dying or a reduction of his life. because the Upper Tribunal found that actually he could receive the same treatment for $2 a month. So, in short, and this has been a rather long video, but it is rather an important case given the number of Article 3 cases. What it tells me is that for someone to pursue successfully an Article 3 case, they are going to need to provide proper and full medical evidence, both from the United Kingdom as to the lack of available treatment or the absence of available treatment, the effect on the individual. It will be necessary to address the individual's credibility in certain cases, and it will also be necessary to produce evidence relating to the receiving country to show that the material or the treatment is not available. It will not simply be enough to say that the person is very sick, because the Home Office will say, well, you could get treatment and you haven't provided evidence that there isn't any treatment. I don't really foresee there being many cases where a receiving country will actually provide any evidence. So therefore, the burden will be on the appellant, as it is, as I say, in most cases, save for those which involve deception, where the burden's on the Secretary of State, to actually prove that they meet the test that was set out by the Supreme Court in AM Zimbabwe. As I say, I apologise for the length of this video. It is an important case because it will affect a lot of people that are relying on Article 3, some involving medical and also mental health issues, and it is important that they're prepared properly. I can help, as can other experienced immigration practitioners, but if one is seeking to pursue an Article 3 case, it will be very necessary to make sure that that case is properly prepared and that all the potential loopholes, as it were, in the evidence are covered. Otherwise, it will be open for the tribunal to find that they have not discharged the burden of proof that is on the appellant. Thank you very much for watching this video. It's an interesting case. However, the saving grace, as I say, is that each case will be fact sensitive. So if you are seeking to pursue an Article 3 case, get a good lawyer. That's the short point. And make sure your evidence is watertight. Thank you very much for watching. Please subscribe to my channel. This is Paul Turner, the Immigration Barrister at Imperium Chambers.